Then every alternate group.
Item number 1.
इसको बोलो ना.
Maybe, Mr. Lordship. I have received today only the copy of the affidavit filed by the state, as per order dated 15/10/2025, Your Lordship.
Union of India has filed an affidavit.
My lord, I have not filed, my lord.
You have not filed. Why?
I contacted the department saying the affidavit may not be necessary for you.
Sorry?
The department is of the view, my lord, affidavit may not be necessary at this
May
time.
not be necessary. Then we record your statement that you submission.
But if Lordship permits me, I think this is the most important affidavit of the Union, because 443...
Yes, but it's a Purasod border.
My lord,
That's why the affidavit is required. With regard to the steps taken by them to prevent entry of narcotic drugs.
for that customs department is empowered, my lord.
No, customs is no. Border is your BSF or whatever is manning it. So you have to file an affidavit. You cannot say I will not. You have taken steps. You must have taken steps. Must have identified the borders, porous borders through which these drugs are coming. What steps you have taken to block those porous borders? So you are through the international borders. That's your affidavit is required.
Customs and Directorate of Revenue Intelligence are working, my lord. They have been empowered by the central government.
No, whatever is there, you put that itself that Union of India has nothing to do customs and then we'll ask them. At least you put something. International border is not being by customs and the DRI. Union of India represents all, whether it is custom or... So one affidavit has to be filed.
I'll talk to them, my lord, once again.
Whether it is customs or whatever your stand, you just put it on affidavit. 1 page, 2 page, whatever is there.
Even Your Lordship, the Apex it also recently, Your Lordship on 25, Volume 5 SSA, they have said it may be declared as a national security. Up to that extent it has gone.
No, that is why I said that the affidavit of the Union of India is necessary.
Well, I'll talk to them.
Customs is there. Then if the custom is there, then BSF is not required then.
But they are working in tandem, my lord. The BSF.
So you put it in affidavit then, no? Whatever you have to say, put it in affidavit. State.
Lordship, so far state is concerned, we have filed an affidavit to the Lordship. Lordship, the relevant paragraphs, Lordship, we kindly have it.
No, but you have given it today
We
itself.
have given the copy.
What is this?
From para 4 onwards,
What is
Lordship.
the affidavit? You find out the steps taken, whatever steps taken, Mr. Mohanty. So,
Your Lordship, I have just received a copy, gone through it little for the state. It is in the paperwork. Actual reality, what is there? Earlier also the same thing they did. Then this Honorable Court directed me to go inspect most of the centers. Then with the help of the Social Welfare Department and their logistics, then we visited and we reported back. Ground zero, it seems everything is zero in the ground. In the paper, everything has shown that they are doing this.
Lordship, kindly have it
Because
from.
if this is the case that as per the affidavit we saw, then what is happening to those minor girls? They're loitering on the street all night.
no, if they are
No
loitering,
de-addiction center. They're never been taken to
if they are
de-addiction.
loitering in the street, then I think you have a CWC to take care of them. If they are loitering in the street, then child in need of care and protection. So they will come under that.
But they are not doing so, Your Lordship. Therefore, the spot inspection is needed, Your Lordship.
CWC is a party? No.
No. By submission, Lordship, at least if Lordship can go through from para 4 onwards, these are.
No, you see, the difficulty is this: we are now seized with only the drugs, narcotics. That is the purpose of the petition, not for the children in the streets. That if you file, we'll take care of it. There's no difficulty on that. So, that if you find out across the cases, then we can call the social welfare, child welfare officer and the CWC members.
All the systems are in place, Lordship.
Huh?
Child welfare officer, social welfare department, these are all in
These are
place.
there. But today we are not seized with this, but yes,
We are concerned
To
with
the
the
extent of if the children are addicted, then that also. So social welfare has filed an affidavit whether they have identified children affected with this. Of course, the children
Yes,
are affected. So have you
Yes, we have
included-
given a detail, Your Lordship. Lordship, kindly just go through it, please. Just, or maybe some other date we can get the case listed again. In detail, Your Lordship, para 4 onwards.
No, what he's saying is this. He's saying that everything is on paper. But what is the outcome of it? It has to be seen.
But as the suggestion again came from a learned senior counsel, Lordship, if he can inspect and then maybe submit a report based on this. Because this is not an adversarial matter, Lordship. We'll do corrective measures. Once system is in place, then the second issue would be the functioning of the system.
No, why can't we form a committee to inspect and file a report to us?
Yes. Absolutely, Lordship. And then the committee can monitor and guide the state even as and when the
So
officers
we
are there.
form a committee. We'll form a committee.
Which has been put as I've seen
Lordship, yes.
in drug rehabilitation.
Yes.
Remission. Yes.
And also at page 20,
Para 10, Lordship.
no, page 24, we find that some of the patients have been treated. It may not be absolutely only a piece of paper. They have indicated something, 24, 23, treatment with patients, IP treatment with number of patients here.
No, it's only the is it a discrimination? What is it? Another government or
Yes, yes.
the Dream is the NGO or is it a government entity?
Part of the government entity, Lordship. And Lordship will just come
Over
straight.
and above these
Yes.
other measures.
Okay. And Lordship will come to specifically to para 14.
Yes.
Lordship, a joint inspection was done by Dream.
That's why I saw this Dream. I said, what is
She-
it?
The Lordship is a part of social welfare department. We have opted them because they are more specialized in handling. So we have taken even expert opinions in carrying out. So Dream, Shillong Cantonment Board, police, Darbar Shillong's local heads.
No, but what happened to the outcome of the letter of 9 December 2024, paragraph 15?
That is, I think we have verified.
We are in November. Paragraph 15.
Paragraph 15.
Page 6.
No, Lordship, the report is at page 27, Annexure A.
No,
Annexure G.
no, it's there. But you said that this entire process will be expected to be completed by November 2025. So we are in November 2025. That is what I'm saying.
Lordship.
So what is the progress made? It should have been completed by this
No,
time.
no, Lordship. Lordship, we'll have to further file a report on this, Lordship.
So we are in November already. That's what I'm saying.
Lordship.
Okay. Yes.
Mr. Khan, who's the mission director of this dream?
FG Khashin, mission director. Your Lordship will have it at page 30.
He's an ex-policeman, IPS officer.
Lordship, not to my specific instruction, but yes, I know him, but I hope he's the same person.
Now, you go through this affidavit, you see some detoxification efforts were taken at page 24, you will find it. But yes, we have to address the root cause of it.
Yes.
So, obviously the drugs are entering. So, the state has to take a responsibility. If it is to the international border, then center has to also explain it.
Absolutely, Lord.
So, you have to file an affidavit. You need to file an affidavit. State affidavit is there. You take whatever you stand. You say custom, dear, whatever you said, then we'll call them. Because you are representing all, whether it is customs or DRI. So that affidavit, you can always put it.
Because what happened, I sent the petition, but they said this is mainly with regard to rehabilitation centers, my lord, in Meghalaya.
No. Rehabilitation is one part. The other part is this entry of that is why I said in the last part, it's nothing to do with the petition. It is with regard to our direction. With regard to the steps taken by them to prevent entry of narcotic drugs. This is our direction. Even if it is not there in the petition, this is our specific direction.
I'll file. I'll take
Please file an affidavit on this. That in the international border, what steps you are taking to prevent this. And what you said about this entry of drug in the state. What is your stand on this?
I don't think so. We have made any specific, because basically, as state, we are the recipient of the effect that happens when the drugs comes inside. So the cause, there can be a multiple cause, maybe interstate, international. So until and unless, Your Lordship, we co-opt the concerned authorities from the center, it will be difficult to.
No, you may have to hold a meeting at the highest level with all the
absolutely.
states who are facing a similar problem and create some kind of team who will monitor the inter-functioning.
Lordship, with my personal experience handling number of bail matters in NDPS, most of the source comes from Manipur. That route.
So if you know that route,
That
you
route is
have
there.
a border
Mizoram is
with
there, most of
you
them.
have a border. So what kind of
And Manipur is an international border again. From there, where is the actual source?
no international border maybe, but with you there is international border.
Manipur, Silchar, Your Lordship, these are the transit route where the high.
Oh, even it comes from downstream area also, Your Lordship. Even from Garo Hills also it comes. The drug. All those reports I have, Your Lordship.
If you have the reports, then you share with them.
Because they're coming to the villages, wherever even the drug has been infected to the rural areas. But government is silent on that.
Government is.
They are not saying anything about the rural areas, what steps they are taking. Nothing. A very pathetic condition.
No, this report doesn't take care of the. How do you know these patients who have been mentioned here are not from the rural area, only from the urban area?
No. I have stated in my petition.
No, in the affidavit that they have filed.
Oh, they have filed, yes.
Yes. So
They have
have you
stated.
said what you have done for the rural areas?
Silent, everything silent.
Nothing in specific, Your Lordship, because we have collected the individuals who are victim of it. Yes, we have not disclosed the identity and the.
No, it's not about the victim. It is about the source.
Lordship.
It's about the cause.
But Lordship can see it, para 7.
We have the results of it, but who is the cause?
Lordship.
Effect of the cause is this
Effect.
person.
As state, Your Lordship, we have specifically answered 3,543 individuals were treated. So we have.
You may be giving the treatment, fine, nothing to do with that. But you have to first address the menace, the root cause, and what you are doing it. Social awareness, drug lords are being taken into custody. See, all those you arrest in the NDPS cases, They are all the carrier, nothing more than that.
Absolutely, Lordship.
Drug lords are always flying high. No one is catching the drug lords. Let us face the true reality. How many of the drug lords have been convicted, you tell me, in your experience? All these lorry drivers, khalashi, someone standing.
The carriers, Lordship.
Carriers.
And
Majority of them are the carriers.
that the cause is poverty.
Lordship has rightly answered. It's a cause of poverty.
Drug lords are never touched. I have an experience 12 years a drug lord was absconding. Ultimately, when I called the SP and I said, now we'll do something, within 48 hours, he surrendered. So this is the power and might they have.
Lordship. Lordship, will kindly see even para 9, we have stated that there is a specific role of central government, even in Lordship, especially Ministry of Social Justice and Empowerment. So,
Paragraph 3.
para 9, page 4, Lordship.
Yes. What do you say on this? State has said you have given the affidavit to them.
No, my lord.
No, sorry. Oh, apology.
Well, these are primarily state functions, my lord. The center maybe aids them, my lord, gives them assistance.
Now, it has been submitted to you for consideration. That is still under consideration. That is a paragraph 9. So you have to respond to it. And as an Union of India, you are protecting our borders. So this is a menace. You have to take a stand what you are doing. What the customs are doing, what the revenue intelligence is doing.
Yeah, there are frequent seizures, my lord. Even the state police as well as customs and
Either there is a lack of manpower or infrastructure or if something is there. So you put it whatever is there, we try to see. Take it down. An affidavit by the Joint Secretary and Director Social Welfare Department Meghalaya filed in compliance of the order dated 15th October 2025 is taken on record. Copy of the said affidavit has been served upon Ms. R. Khan, learned advocate on record for the applicant only yesterday. This affidavit you have served them?
Sorry, Lord.
When you serve the affidavit?
This morning, Lordship.
Just now.
We filed the affidavit this morning, Lordship.
Is served in court, is served during hearing. Is served in court today. Good start. Mr. S.P. Mahanta, the learned senior advocate, submits that the matter will be adjourned in order to enable him to go through the affidavit. Ms. N. Mosika, the learned GSGI, has submitted that has paid for time to file an affidavit in terms of the earlier order, as there is a specific direction upon the Union of India to file a detailed affidavit with regard to the steps taken by them to prevent entry of narcotic drugs in the state through the international borders. The affidavit is also necessary in view of the statement made in paragraph 9 That's another thing. Just another thing, Mr. Khan.
Lordship.
Uh, the state is also directed to file a supplementary affidavit disclosing the steps taken by them with regard to drug menace in the rural areas
Lordship.
of the state and steps taken by the state to prevent such abuse and drug menace.
My lords, on the
May
last
please,
occasion,
Yes.
Your Lordship, this is relating to tourist taxi services and policy relating to that, my lord. Am I audible, my lord?
Not clearly.
this is a matter, my lord, where a group of taxi associations, my lord,
Oh, yes.
they called for a
Yes,
strike.
yes.
Yes,
And my
the
lord has done.
committee has been formed, my lord, and in committee has held meeting with the association, my lord, and committee is examining the various such agreements with the other states. Committee will meet by the end of this month again, my lord. Lordship may have it after 2 weeks, and then we will place some report on that.
The learned advocate general.
May I please, Your Lordship? As per the last order, my Lord, 28/10/2025, the notice of service to the respondents, my Lord, 7, 8, and 9, by way of dusty, we have served, my Lord. Kindly grant us some time, we'll file the affidavit of service, my Lord. We have received the acknowledgement notice, my Lord. We'll file, my Lord, tomorrow, my Lord. Affidavit of service, my Lord.
No, but it was served on 31st October. So had it been served?
My Lord, yes, my Lord. My Lord, by way of dusty, my Lord, personal service, my Lord.
It has been.
My Lord, dusty.
Where is the affidavit service?
My Lord, I received, my Lord, through in my scan copy, my Lord. I'll file the affidavit of service, my Lord, by way of an affidavit, bring it to the record of this honorable court, my Lord.
Well, tell us. Yes, you are there, 1 to 6.
Lordship, yes, I'm for the state respondents, yes. Respondent 1 to 6.
Who are these 7, 8, and 9?
My Lord, 7, my Lord, the secretary to the managing committee of Rajabala Higher Secondary School, and my Lord, respondent number 8 is my Lord, 7 is Rajabala School represented by principal, 8 is secretary, my Lord, 9 is
West Garments.
My Lord, West Garage. My 810, my Lord. Because prior to this, my Lord, we have taken step by way of, my Lord, postal service. Then we have filed an affidavit of service, bring on record to the that the same was served to the 7, 8, and 9.
Which is not accepted by this court because it's
My
to
Lord.
the post office.
My Lord, yes, my Lord. Then my Lord has passed a direction on 28/10/2025, whereby directed us
saying
to.
that today the nons appeared. Maybe they have not been served at all.
No, my Lord, I have received the copy, my Lord, the acknowledgement. I will file by way of an affidavit, my Lord. Today only they have sent in the WhatsApp the scanned copy of the acknowledgement, my Lord. I just couldn't file, my Lord. I'll just, during the course of the day, I'll file, my Lord, the affidavit of service, my Lord.
It's an appeal against order of review.
My Lord, this is an appeal, my Lord, against the order of the review and the, my Lord, judgment and order dated, my Lord, in WPC, my Lord.
No, you can't have an appeal against a review. You can't have an appeal against a review.
My Lord, against the main judgment, my Lord.
So the main judgment you have not challenged.
My Lord, we challenged, my Lord, in the main appeal. Appeal has been not yet admitted, my Lord. Since miscase,
No, what miscase?
my Lord, there is a
You have to
delay of.
Provided there is we find that you have preferred an appeal against the main judgment.
Yes, my Lord.
What is the date of the main judgment?
My Lord, the judgment.
The date of the main judgment is 26 June 2023.
My Lord.
And you have preferred an appeal against the 20th June, but you have not annexed the order of 20th June.
My Lord,
You have not annexed the order of 20th June. You have annexed the order of review. Passed on 1st May 2025. The department ought not to have accepted it. The one that you have annexed
yes, my Lord.
is a judgment passed in review.
Yes, my Lord. The judgment.
But your cost title says something else.
My Lord, judgment.
Then this judgment is you withdraw file fresh. This is not.
I'll correct it, my Lord.
You withdraw file fresh. Lay down.
My Lord, I'll take a leap of this court, my Lord.
In view of incurable defect, the appeal and the application stand dismissed as withdrawn. Subject to the laws of limitation. Subject to the laws of limitation. Subject to the laws of limitation.
I'll just pray, my Lord, one more thing, my Lord. With the liberty to file a fresh, my Lord.
It says the subject to the laws of limitation. Yes.
Hello.
Annex one thing. Just
It needs some more time to prepare the paperwork.
Just give us one moment. You are for the petitioner.
Yes. Respond.
Who is for the petitioner?
No, he's for
So, you know,
when they file the writ petition.
The appearances are wrong.
Respondent.
What does this matter? Where is the paper book?
you receive the paperwork I have to prepare, you receive just addressed to me. And I have to collect some documents from Central Administrative Tribunal.
The 14th October you passed this order. Today you are on 17th November. You could not prepare the paper book.
Recently,
How long
it is
it
addressed
take?
to me, you receive.
Sorry?
Recently, it is addressed to me. I have to collect these documents from.
Why they should recently give it to you when there is a court order? Henceforth, we will direct the departmental head to be present before us, explain a reason for not complying with the court's order. In spite of our order, if the papers are not made available to you, you disclose the person who is responsible, call him in court. Directions when passed by the court has to be obeyed. You 2 weeks time. Not more than that.
Your Lordship,
Because they are not receiving the benefits because of the pendency, it seems.
Your Lordship, in this matter, I have to collect from Central Tribunal the documents.
What?
I have to collect these documents from the Central District Tribunal, Your Lordship.
You are not the appearing counsel before the CAT?
No, Your Lordship.
But doesn't matter, your client will have all the papers.
I have a requisition with but I didn't get, Your Lordship. I have a request them that they bring the file. It's not there in their file.
What documents are missing?
My lord, certain circulars, the vital circulars are not enclosed.
That is the
By
only...
which Government of India extended the benefit.
Sorry?
Benefit of higher pay scale.
No, those are not in the writ petition.
Not in the writ petition.
So those papers are with you.
In the Central Institute, we have filed those petitions, those papers.
Are the documents presently available with you?
My lord, these are my original application. It is there, but these cannot be. These are highlighted and.
Keep hold for the original report. Yes. You can't prepare an affidavit, paper book. Record has come. So, when the record has come?
This September 2024.
17th November. So you can't prepare a paper book because of lack of papers lying in this CAT.
My instruction was this, that they have to collect from
You are an advocate of the court. Should you not inspect the record to find out whether the CAT records are here or not? And it's sure that when we pass this order on 14th October, we are aware of this. It must have come to our knowledge, otherwise we would not have passed this direction. All that you are required to collate these papers and file a proper index and file a paper book. That's all. We'll give you 1 week time. Or 10 days at the highest. Take down. The time to file paper book in terms of the earlier
Yeah, I'm too slow.
Yes, yes, yes.
May it please your lordship.
You're for the appellate.
No, I'm for the state, your lordship.
You're for the
Petitioner, my lord. This is a writ petition, my lord. We are challenging the vires of the amended rules, service rules. my
So
lord.
who is the writ petitioner?
I'm the writ petitioner.
Yes, tell us.
Yes, my lord. Now, my lord, this matter was heard at length on the last occasion, my lord. If your lordships recollect, this is the matter where your lordships had observed that where has the 10%, my lord, vanished. Now, in 2008, my lord, when we joined our subordinate service, we were governed by the 2008 rules, my lord. And under these rules, the promotion, the recruitment to the next higher post was 65% by direct recruitment, my lord, and 35% for us, my lord, by promotion. Your lordships will find the rule at page 25 of my petition, next to 3. But if your lordships may kindly have page 25 of the writ petition, these are the 2008 rules, my lord.
Page 85.
Page 25, my lord, 25, annex to 3.
Yes. Yes.
Lord, page 25, these rules are maybe called as Meghalaya Fishery Subordinate Service Rules 2008 at Rule 1. Now, page 26, your lordship said. You will find Rule 4 at page 26. So there's grade 1, grade 2, and grade 3.
Affidavits, you have filed affidavits.
Proceedings are complete, my lord.
Lordship, we file also the affidavit of clarification, your lordship.
This is only affidavit, correct?
So at Rule 4, the promotional post is grade 1, my lord, fishery officer. And the method of recruitment is, your lordships will find at Rule 7 at the bottom of the page, at page 26.
Yes.
So that as per Rule 7, which reads, my lord, appointment to the post of fishery officer and research assistant shall be made in the following manner. Sub-Rule 1, my lord, by direct recruitment on the result of examination. Sub-Rule 2, by promotion from amongst fisheries supervisors, laboratory assistants who have rendered not less than 5 years of service, as such who have completed successful and prescribed course of training for the post held by them, included in the select list approved by the rule, under the rule,
provide further that the incumbent has a minimum qualification of so and so. I'm going to sub-rule 3. Now, sub-rule 3 provides, my lord, that the proportions of vacancies to be filled by the government in any year in accordance with clause 1 and 2 above shall be 65% by direct recruitment and 35% by promotion. So they say here in any given year. Now there's a proviso to this sub-rule, my lord, which says, provided that the number of persons recruited under sub-clause 2 above shall not exceed 25% of the total strength and the grade of the service. Now this proviso, my lord, is creating a confusion if we read the rule as a whole. However, if your lordships may kindly come to the schedule, which your lordships will find at page.
No, so 35% was segregated between 25% and rest 10% kept blank.
Yes, my lord.
Out of, see, 35% proviso
Yes,
has reduced the, or rather carved out 25%, out of this 35%, 25% will be, they shall not exceed 25% of the total strength of the grade in that grade of the service.
yes.
So 10% has been left open.
Yes, my lord. Now, my lord, this is clarified by Schedule 3 to Schedule 2 to these rules. Page 36, my lord. Page 36, my lord, Schedule 2.
Page 36.
Page 36, Schedule 2, my lord, has earmarked
Yes.
So, Schedule 2, my lord, has earmarked 35% for promotion of the total cadre strength. And below that, my lord, 65% for direct recruitment, my lord, of the total cadre strength. So, my lord, in my humble submission, this schedule, my lord, has clarified the position of Rule 7, where 35% is earmarked for promotion and 65% for direct recruitment, my lord. Now, my lord, pursuant to entering service, my lord, thereafter, my lord, in 2017, new rules were, my lord, notified for the higher service. Now, this particular post was carried, my lord, over from the subordinate service rules to these 2017 rules, which are called the Meghalaya Fisheries Service Rules 2017, which your lordships will find at page 40. Now, the relevant rule is again Rule 7, Sub-Rule 5 at page 42, my lord. So, the post was repealed from the previous rules, my lord, and brought into these new rules.
Yes.
Now, my lord, under the new rules of 2017, here, my lord, at page 42, sub-rule 5 of Rule 7, the percentage, my lord, the quota is clearly quantified, my lord. It reads, my lord, appointment to the post of fishery officer shall be made in the following manner. 65% by direct recruitment based on result of competitive exam, and sub-rule 2, 35% by promotion from amongst the members of the Meghalaya Fisheries subordinate service holding the post of so and so. Then, my lord, again at sub rule 3, they say that the proportion of vacancies to be filled by the government in any year in accordance with clause 1 and 2 shall be 65 by direct recruitment and 35. Then again comes this confusing proviso, my lord, in my humble submission. Provided that the total number of persons recruited under clause 2 above shall not at any time exceed 25% of the total strength of grade 3 of the service. Now, my lord, according to us, this was creating a confusion, my lord. So, my lord, thereafter, we have made several representations to the government, my lord, to rectify this, to remove this, omit this proviso.
Grade 3 was not there in 2008.
In 2008, my lord, it was under the subordinate service rules.
Grade 3 was not specifically mentioned.
Yes, my lord. So, in the new rules of 2017,
They mentioned grade 3 specifically.
yes, correct, my lord, correct.
So grade 3 was not mentioned.
Was not mentioned. It just
So
says
here-
vaguely.
So you may have in the service, you may have different grades.
Correct, my lord.
So once you describe it as, say, for example, as described in the earlier notification,
Yes,
in that grade,
yes,
so it means that one composite grade, but that grade consists of various grades,
Yes.
subgrades.
yes, my lord.
So grade 3 is one of them.
Yes,
So this 25% grade 3 has been given benefit here that you may consider whatever the 30 out of 35% from grade 3, it shall not exceed 25% of the total strength of grade 3.
grade 3, my lord.
So if grade 3 there are more, so that will be restricted 25% only.
Yes, my lord.
For this purpose of 35%, it qualifies that this 35% would consist of those service tenure holders in grade 3, but there the presentation in that 35% would not exceed more than 25%.
One, my lord, clarification. This grade 3, my lord, if your lordships come to page 41, rule 4, composition of service. Page 41, the same rule, 2017, my lord.
Grade 3 is the fishery officers.
Yes. So they are talking about this promotional post, my lord.
So for grade 3 fishery officers,
Yes, my lord.
suppose there are 100.
Yes, my lord.
So 25% of 100.
Yes, my lord.
Suppose 35% will consist of grade 3 officers whose number shall not exceed more than 25% of their
25%.
strength.
25%. But
Suppose grade 3 has 100, as I said. So 25% of that will be eligible to fix up with the remaining, with the 35%. Remaining 10% is clear.
correct, my lord. But if your lordships again kindly have sub rule 2, because in 2017, in sub rule 1, it is clearly, my lord, specified that 65 by direct recruitment and 35 by promotion. So it's already, my lord, earmarked 35%. Now by a proviso, my lord, you come up with a contradiction saying that no, beyond 25, you cannot be promoted.
No, there is no contradiction.
It is a contradiction, my lord.
Carved out an exception. Proviso sometimes offer as a clarification.
Yes, ma'am.
Sometimes it offers as an exception.
Yes, my lord.
So it says that here they have very consciously said grade 3. They have not touched grade 1 and grade 2.
Correct, my lord.
So grade 3 will have only 25% representation of the total strength.
My lord. My lord,
So
grade 3,
10% will not be, so this 35% by promotion, this grade 3 will have 25% representation in the 35%.
my lord, this grade 3 itself is a promotional post. That is what I'm trying to point out.
It's a promotional post.
Yes, my lord.
So for the rest 10% also it made promotional.
Yes, my lord.
There may be grade 2, there may be, is promotion to which post?
My lord, if your lordship sees grade 3 is fishery officer and sub rule 5 is post appointment to the post of fishery officer.
Yes. So for the purpose of appointment, the fishery officer,
In the following manner, 65 and 35 year marked. And in the proviso, they reduce it by 10%, my lord.
So 25% of the total strength of grade 3.
Is earmarked, my lord.
So 10% will be open. Yeah? Promotion from other grade.
I can understand a situation where they say, my lord, where they say that not more than 25% of the lower post, my lord, strength of the lower post. Here, first, under sub-rule 2, the earmark 35%, and by the proviso, they reduce it by 10%, my lord. That is why I say it's a contradiction, and that is why we have been representing to the government.
No, this grade 3 is a promotional post.
Yes, my lord. 35% is earmarked for promotion.
Yes. So suppose grade 3 has 100 posts.
Yes.
So 25% of the posts should be out of this 35%. Number of persons to be recruited shall be 25% of the total strength of the grade 3. If grade 3 is 100, then from this 25% of 100 will be considered for the post of fishery officers.
Fishery officer is grade 3, my lord.
Yes, to that post, it will be promoted from the post of Meghalaya, this subordinate service. So it's a promotion for the subordinate service.
Yes, my lord.
So from subordinate service to fishery officer.
Yes, my lord.
So subordinate service to fishery officer, in this promotion, 25% of the total strength of grade 3, what will be there? That will be out of this 35% of promotion, 25% will be from this. So the 10% remains.
Yes, my lord.
From any other category.
Page 80, my lord, annexure 11, these are the impugned rules. These amendments, my lord, were notified in 2023. These are called the Meghalaya Fishery Service Amendment Rules 2023. So amendment number 2, my lord, that is amendment to Rule 7, Sub-Rule 5. Here, they have increased the direct recruitment to 75 and reduced the promotion to 25. And also, by way of proviso, my lord, they have provided that my lord, members mentioned under
Shall
this
not
clause,
less than 5
not less than
years.
5 years. Now, my lord, this clause was never part of, my lord, the old rules when I entered service, my lord. There cannot be any classification on the basis of number of years of service. So my case is, my lord, when I entered service, my lord, the rules that were governing my services, my lord, provided that 35% will be earmarked for promotion, for consideration, my lord. Now, by this amendment, my lord, it has been reduced. There were some contradictions in between. We have been writing to the department to kindly, my lord, remove these anomalies. Instead, they've come up with this, my lord, amendment. And in my rejoinder, your lordships, on the basis of the gradation list.
No, what affidavit they have filed?
My lord, in the affidavit they have filed, my lord. This is
What are
dated
the affidavits?
17th of September 2024.
Where is that affidavit?
Para 4, 6. Lordship, para 4 and 6, Your Lordship, we have explained at page 4 of our affidavit, page 4 and 5.
No, paragraph 4 is something you see. You cannot have a concept of direct recruitment and promotion are different. Then you are directly recruiting for the post of fishery. You cannot be provide that promotion to the post of fishery officer shall be 65% by direct recruitment. No.
Recruitment.
Direct recruitment cannot be a promotional post. It's a direct recruitment. You want to fill up that post by direct recruitment and by promotion.
65 to 35, Your Lordship.
So it's not a correct expression. Promotion to the post of fishery officer shall be 65%. No.
No, Your Lordship.
Fill up the post 65% by
Direct recruitment,
yes,
and
It's
35
wrong,
by
wrong
promotion, Your
description.
Lordship.
Your paragraph 4 and 5, your paragraph 4 is ambiguous, but paragraph 5 is paragraph 4 is ambiguous. Paragraph 4 you have not followed what you exactly mean by this.
Paragraph 4 of the main affidavit, Your Lordship.
Clarification affidavit. No, our specific question was that before this amendment was carried out in 2023, what were you doing with regard to 10%?
Lordship, that has been that has been clarified in paragraph 5, Your Lordship.
No, I'm reading this, but you have to show that in the past also this 10% was filled up by direct recruitment.
Lordship, we say in paragraph 5, Your Lordship, that is humbly submitted that before the amendment
No. This is not. We are not doing any. We have to have the actuals. It's not a question of deciding on a theory. What would happen, what would not happen is not the issue. You have to show the actual ground reality. Your explanation is this, that this 25% cap, grade 3 fine, our case was what would happen to the 10%. So you need to demonstrate, please, you need to demonstrate that in all those years in 2008 or 2017, you had been filling up these vacancies, treating it to be part of 65 plus 10. That you have not shown. That you have not shown. These are all theoretical discussions.
Lord, may I show for my rejoinder, my Lord?
We say, Your Lordship, we say that.
No, does it actually happen? How you have understood the rules during that 2008 and 2017? That is exactly what we wanted to know from you.
If Lordship kindly have again paragraph 5.
We did it. This is what we try to explain. If this is there, then this should be there. We don't want that. We want it from you. What does your record shows? That in 2008, when this was the ratio, 2017, this was the ratio. How you treated? You cannot fill up 10% by direct recruitment unless your advertisement also allows you to do so. So how this 10% has been filled up? Where is that explanation?
We say,
if you treat this, how you have treated this 10%? You said that it will merge with the direct recruitment.
It carried over to direct recruitment, Your Lordship.
It cannot carry over to direct recruitment. You have fixed a percentage. At any given point of time, will you be able to show before the 2023 amendment that because once you carry forward this vacancies, then it is no 65%. It will be carried forward also. So 65 plus 10, it becomes 75.
75, Lordship, yes.
So in 2008, were it 75-25? Was it 75-25? That is what we want to know. This clarification, you have not clarified that.
May I point out from the gradation list, my Lord? It's part of my rejoinder. I prepared a chart.
See, exception they have made out. 25% in grade 3 would mean you can't have 10% for that. It is quite clear. The 10% should merge automatically with 65%. We have to give meaning to the proviso. It's a very, sorry to say, it's a very defective drafting. What they have done is a correct thing. 2008 is, if they have left it there only, the matter would have ended there. Or if they have clarified, because 2017 makes it more complicated. But thing is this, yes, you cannot say that how many posts they will fill up through promotion or not. That you cannot have a say. That is for them to decide unless you show that it's absolutely manifestly arbitrary. When you join a service, yes, you have a right. You have a legitimate right that you have a chance of promotion. You can claim right of promotion, you can consider to be your right. But how to be the percentage of that, whether it is 25% or 20%, that is for the administration as a policy decision of the government. That normally the court will not interfere with that unless It violates Article 14 and other provisions of the Constitution. So here, you cannot say that when you join, because all throughout, even in 2017, they have said 25% of grade 3 at the highest is supposed to be filled up, meaning thereby this 10% would merge with 65%.
My lord.
That should. But how they have conducted themselves, that they have not clarified. What you have done in
kindly have the
2008,
rejoinder, my rejoinder for a minute, my lord.
that will not take your case any further. Whatever your rejoinder may be.
My lord, there's the third prayer, fourth prayer also, my lord. Kindly have. Lordships, kindly have my rejoinder. This is as per the gradation list. If your Lordships, kindly have para 11, page 6.
Para 6.
Page 6, para 11, my lord. The bottom of the page, your Lordship, will find a table. Now, this table has been prepared as per the gradation list, which I have enclosed from page 48 onwards, my lord. In 2015, my lord, there are a total of 28 posts. In 2015, 18 persons from direct recruitment were occupying the post.
Paragraph?
This is the paragraph 11, the table, my lord, at page 6. It starts.
Number of posts directly 18.
Yes, 28. Direct recruitment 18 and 35% 10. Now, my lord, just to show the occupancy, as per the gradation list in 2015, 18 persons were by direct recruitment holding the post, that is 65%, and 2 persons by promotion, that accounts to only 8%. Next page, my lord, at page 16, direct recruitment again, my lord, 18 persons, that is 65%, and only 1 person by promotion, that is 4%. In 2017,
Yes, 1 person. See, 2015 number of posts is 18. That is 60.
so 18 occupied by direct recruitment.
Correct.
Out of 28.
And 2 is out of promotion.
Out of promotion. We account to only 8%.
Vacancy is 8. 8 posts.
27%.
Now this 2 is of 35% or 25%?
Yes, my lord. Even if we say 25%, my lord.
Now that they have to clarify. 35% promotion is the 10 number. It is 18.
What I'm saying is, my lord, even if it's 25%, even that also they're not fulfilling. Now, your lordships kindly come.
But have you, Mr. Counsel, have you dealt with paragraph 11? We need to deal with, you need to deal with this paragraph 11 of the supplementary affidavit.
No, your lordship, we have not.
You file an affidavit dealing with this.
Lordship.
2018, my lord.
How it works, we want to know. We are not on theory. We are not to how you have interpreted the norms and how you filled it up. Right now. What was the last order? Yes. The clarificatory affidavit. Best thing would be like online justice.
Item number 1.
Yeah.
May it please, Your Lordship. This is the matter relating to Harjan Panchayat Committee, my lord. We have been trying to find out solution. In fact, we have approached the cantonment board for allotment of land, my lord, nearby, my lord, because they are sitting in this piece of land which belongs to government of Meghalaya. So we have decided, and we have been negotiating with the committee, my lord. There have been several meetings with the committee, my lord. So there is a adjacent land in cantonment board, my lord. So we have approached the cantonment board for allotment of land, and we are awaiting the response, my lord. Your lordship may have it after 4 weeks, my lord, if we can find solution. Otherwise, we will argue the matter, my lord, on merit, or it can be referred to community mediation also, my lord. It can be referred to mediation also.
That particular community mediation, I think, has not yet been notified.
Yes,
Has it
my
been
lord.
notified?
So if not, it has not been notified, my lord.
It's
It
not
has
been
not been.
notified. That is a problem.
Yes,
Community mediation would have been the best thing.
yes, my lord. Because there are communities involved in this case. Besides, it's a government land, my lord. But communities is also involved.
But I think that there is no bar in passing a judicial order on that.
Yes, my lord. Because it's a question of
You agree to a community mediation?
Committee mediation. Rashid, it may be taken after 4 weeks. I'll just take instructions from my client. Because the community council is from Delhi.
What is the dispute?
dispute, my lord, is a very short one. This is a piece of land, my lord, owned by Shillong Municipal Board, my lord. The residents are belonging to Sikh community, and they were sweepers working in the Shillong Municipal Board, my lord. They were given quarters by Shillong Municipal Board, but over the period of time, my lord, they came to occupy the piece of land. Government of Meghalaya, and then there was some slum development in the area. Government of Meghalaya constituted a committee to look into this issue. This issue, this constitution of the committee was challenged by Harjan Panchayat committee by way of writ petition before this honorable court, my lord. The learned single judge said that this is a disputed question of fact, and therefore writ court can't go into the issue. But at the same time, direction was issued that government can evict the unauthorized occupants only by way of filing a case in court of law, my lord. Our case was that it is a public premises, it is a public piece of land. It is covered by Public Premises Eviction Act, Meghalaya Public. There is a state act, my lord, and we will take proceedings in accordance with law if we have to evict them under the Public Premises Eviction Act. That's the issue. So we are agreed, but that part of the order and writ appeal was filed by us on that. After 1.5 years, the Harjan Panchayat committee also challenged that order before your lordship, and all appeals have been clubbed together. But in the meantime, both Harjan Panchayat committee members and the state government at the level of ministers, my lord, they had several meetings, my lord, where some alternative land was being offered, which was not acceptable, and there was shifting of some temple, gurudwara, and church also on government land, my lord. So then, Cantonment Board Act, my lord, has recently been some amended or repealed, my lord, and this there is some piece of land with Ministry of the Cantonment Board. I have spoken to Commissioner Secretary. He has said that they have approved the Cantonment Board for allotment of land, so that if the land is allotted by Cantonment Board, we can do some resettlement under some Government of India scheme of the persons who are unauthorizedly staying in the government land. That is the entire case, my lord.
No, so basically, settlement of the unauthorized occupants.
Yes, my lord.
But Lordship, this is the land doesn't belong to the government. The Public Premises Act is not applicable to that.
No, no.
particular.
On what basis you are occupying the land?
We are occupying because it is a tribal land. It is
On what basis you are occupying? What is your legal right to occupy?
land we have been occupying on the basis of the patta issued by the same of Millim. It's a tribal land. It's not a government land. Here in Meghalaya is a different.
No. Public premises, forget about this. What is your right to occupy the land? On what basis you are occupying the land?
No, the land is settled with us by the same, by the tribal institutions. It is not belong to the government. In Meghalaya, land systems are different.
No,
Because
you-
they
you
have the
want to-
land in the European world that belongs to the government, but this land doesn't belong to the government. For the reason that a single judge has said, it is disputed question of facts, and that's why the government is directed to prove
Now,
their
government is
title.
saying it's a government land, you are saying it's a tribal land.
It's not a government land.
Sorry?
It's not a government land. It's a tribal land.
We ask you, what is your tribal government? You forget. What is your.
No, we have.
You have been working with the municipality.
No, that is their contention, but that is not. We are not accepting.
What is your
that.
contention?
Our contention is that we have been living. Those who are working in municipal and not working in the municipal, there is a large number of people. They settle down in the area and they are having a patta. There is a gurdwara. There is a mandir. There is everything is there. And government is now claiming, but for the government also doesn't have anything to show that this is a government land.
No, but the record will show this is a tribal land.
It's a tribal land. It's settled by the Seam of Millim. Seam of Millim also is a party in this case.
Lordship, kindly see the order, my lord, of learned single judge at page 28, my lord.
Now, you are claiming it to be a government land.
I am claiming it to be government land.
And they are saying it's a
they are
tribal land.
claiming
It's a
it
tribal
private
land.
land, my lord. So the writ court says that yes, it is a disputed question of fact. It cannot be decided in the writ, my lord. We have no grievance to that extent, my lord. The writ court, my lord, the learned single judge says, my lord, that now if they want to evict or remove them, they are to approach civil court and civil court will pass the order, my lord. Now this direction, we are agreed with this part of the direction, my lord, because if it is a government land, because they have a right to contest this before the public premises.
See, the dispute, essential dispute is it a government land or not.
Yes, my lord.
So if it is a government land,
they are saying
no,
it is
what
a
you are putting the cart before the horse. You assume for the time being that it's a government land, so you initiate a proceeding. They are saying no, it's not a government land, it's a tribal land.
Private.
So whatever is there.
Yes, my lord.
So we'd only say that if you have any right, you proceed in accordance with law.
We will take steps in accordance with law, my lord.
Very well. We are not deciding whether it's a government land or not a government land.
We will take steps in accordance with law only, my lord. But the direction that you go to the civil court, my lord, without examining
We are not saying civil code or any
Yes,
other
my lord.
code.
I bow down, my
We
lord.
only stop by saying that this is a disputed question of fact, which cannot be decided. Matter ends.
Yes.
If you have any right, you proceed according.
Lordship, only my
Yes, my
humble prayer
Yes, my
that
lord.
the counsel of this case is from the Delhi. So any date by next week, he will join for the VC.
No, we are not deciding that. We are simply.
Because because they have my client also engaged a counsel from Delhi. Only after a week only it can be taken up. He will join through the VC.
Where is the impugned order? Let's see.
Page 27, my lord. The impugned order starts from page 25. And at page
Where is the memo of
27, paragraph 6, your lord, will kindly see.
You should have always the memo wrapping separate.
Lordship, kindly come to page 27, paragraph 6, my lord.
So this order protects you.
This
This
order
order protects you.
The order of single judge protects us because they are directed to go to civil court. Lordship, if you see the 6 schedules, it will be clarified.
Your Lordship will.
We are not entering.
And
This
this-
order protects you. They say if they have any right
Yes.
to evict you. We will only modify this that if they have any right to evict you, they must proceed in accordance with law.
Lordship,
If they have any right.
Lordship, the matter after a week only, Lordship, just my request, because the conducting counsel is from Delhi. Maybe by next week, Lordship.
No issue.
But there is no possibility of any settlement, correct?
Yes.
We
Possibility
are
of settlement is there.
trying, we are trying exploring, my lord, because if we don't want to use force or any, we have been speaking to them. In fact,
No, in
Gurdwara
any event,
Prabandh-
you cannot use force because you have
Yes,
the
my lord.
order says in any way.
In accordance with law, my lord. We are not using at all, and we are not. We do not intend to also, my lord. That is our intention is clear. We want to have amicable settlement with the parties. In fact, number of discussions and meetings at highest level have taken place. We are trying to find the alternative piece of land. They have agreed to some extent at some stages of negotiation, but they wanted adjacent land to this place. And then Cantonment Board has some piece of land to which Government of Meghalaya has approached, my lord. We are awaiting their response, and we
So
will
should
take
we
it.
adjourn it for should we adjourn it for 2 weeks in order to receive a response?
Yes, Lordship. Your Lordship may have it after 2 weeks. That will be possibly we'll get the response, and if we can
No,
resolve
but
this.
should we record that you are contemplating a proposal for allotting an alternative land?
That may not, because stage will come, because if we do not get the piece of land, my lord, then we'll have to go in accordance with law only. But this is as a goodwill gesture,
Take down.
and
The
we are
Land
doing it
Advocate
for-
General has submitted that efforts are being made to settle the disputes amicably, and the matter will be adjourned for 2 weeks. In the event no 2 weeks, full stop. You have not filed the affidavit.
My lord, having gone through the affidavit which appellant had filed on the last occasion, we find that nothing new has really come out. So, response is not required.
Yes.
In that case, my lord, I'm praying that this matter may kindly be heard after 2 weeks, my lord.
Why not today?
My lord, Mr. Pandey, who is conducting this matter, my lord, due to personal commitment, my lord, he will not be available, my lord, today as well as in the coming days, my lord.
What is the issue?
This is the matter, my lord, regarding job in exchange of land, my lord. The corporation has taken our land but not given us the proper job.
Okay, no. The Land Council for the respondent, the Land Council for the respondents has submitted that yes.
But there is an appeal against the order of the London single judge, my lord.
Sorry?
appeal against the order of the learned single judge. But here what happened, my lord, the learned single judge relied on and referred to an earlier order passed by division bench of this honorable court, my lord. Total reliance is placed on that judgment, my lord. And the only thing is, my lord, that we have preferred an SLP against that division bench's order, and that is still pending, my lord.
Review as a preferred division bench order.
Yes, my lord. If I may take your lordship to the impugned order, my lord, of the passed by the learned single judge.
So you also prefer another SLP against our order.
My lord, why I am saying, my lord, because there are more than 150, because in earlier matter also what happens, my lord, a batch of people came, my lord, and to serve them notice, my lord, it took us 1 year in Supreme Court, my lord. The same thing here.
But at what stage is the matter before the Supreme
But the matter was listed on 13th November, my lord.
13th November?
13th November, and no date has been fixed after that, my lord.
But you expedite the matter because otherwise we keep it after vacation, but you expedite the matter in the meantime.
My lord.
Most of the judgment they have implemented, and I have given in my affidavit in reply, many of the judgment they have already implemented, and benefit have already been extended. I have given a chart with in my affidavit in reply.
But the division bench judgment.
Yes, they went in some of the cases, even they tabled to the Supreme Court, your lordship, SLP dismissed. And lot of bunch of judgments I have brought. These are the bunch of judgments which are implemented, and some of them only on the last occasion they went to the Supreme Court in against.
I do not dispute that. My only
and some of the implementation order.
Just a minute. But if you have implemented the judgment,
my lord,
it is already there.
If I may just submit, my lord. My lord, there are 18 technical trades in Assam Rifles, my lord.
18?
18 types of technical trades, my lord. And others are general duty soldiers, my lord. And these are technical people in Assam Rifles, my lord. Now, because during 5th Pay Commission, my lord, certain recommendations were given. Now, trade by trade, my lord, some people came before this honorable court. If I may just take your lordship to one document, my lord, that will clarify the aspect, my lord.
No, but just please tell us,
my lord,
that the division bench judgment on which the learned single judge relied.
Yes, my lord.
Now that division bench judgment was delivered on in the year 2022.
Yes, my lord.
20th April 2022.
Yes, my lord.
We are in 2025.
Yes, my lord.
There is no stay.
There is no stay as some of this. The civil appeal has been, the appeal has, SLP has been admitted, in fact, my lord. It's registered as civil appeal now of 2024, my lord. I only have one copy, my lord. Kindly explain.
Yes.
Put that.
SLP was admitted.
Yes, my lord. Civil appeal number has been registered, my lord.
But there is no formal order of admission of SLP. The matter is taken on board. SLP number has been given.
Civil appeal number has been given.
But this is not the first order.
This is not the first order. This is the order of 9th September, my lord. It was directed to be listed on 29th October. Thereafter, my instruction, it was listed on 13th November again, my lord.
Now, are they represented? Are you represented there in the Supreme Court?
My lord, some of them, my lord, they say that
different set of counsels in Supreme Court.
No, but your clients, the appellants before us.
No, here, my lord, in this case they have not gone. In this case,
they have not gone. In the other matter, they have gone.
Other counsels are also there, my lord. And my lord, a bunch of judgment I have given.
You are saying otherwise the judgment is correct of the learned single judge. But the basis of the order is the division bench judgment, which is under challenge.
Yes, my lord. And if the SLP is dismissed, my lord, I have nothing to argue, my lord. We are covered, my lord. There is no dispute about that.
Yes, a bunch of judgment I have given, which was, my lord, by this honorable court, have passed and implemented.
Sorry?
A bunch of judgment I have given, this honorable court have passed, learned single judge, then division bench upheld, and most of them have been implemented. And those judgments which were
No, but
implemented,
they are similarly placed.
similar, same issue.
Trades are different, my lord.
Trades are different.
Trades are different.
Havildar,
Trade, my lord.
Trade.
If I,
Oh, trades are different. Okay.
18 technical trades are there. Most of them have approved now, and most of them got the judgment in their favor. And many of the judgments have been implemented. And
So
I
what
have
is the
given a list of
distinction
chart.
between those cases and these cases?
my lord, the distinction arises from the office memorandum itself, my lord. The office memorandum said, my lord, if I may just draw your lordship's attention to one page only, my lord.
So this similar office memorandum was not there in the other cases.
Yes, my lord.
Just
My lord, kindly come to page 78 of the paper book, my lord.
78.
We filed a paper book, my lord.
No, please tell us first whether the similar memorandum was there in the other cases or not.
My lord, what I am submitting, my lord, 3 trades, my lord, 3 technical trades were treated separately, my lord, in this office memorandum. And they have been granted relief pursuant to orders passed by this honorable court.
These grounds have been rejected by the Learned Division bench.
So these 3 grades,
My lord.
they have been allotted the benefit
Yes, my lord.
of pay revision.
Yes, my lord.
So his trade was not considered there. He's not there.
No, my lord. That is our case, my lord. They are electrician, my lord, basically.
Same argument made in all the cases and have been rejected by the Learned Single Judge as well as by the Division bench. Same argument. My lord, one of the judgment, in the bunch of judgment, Lordship will find my friend has argued. That is
Same
Digambar.
memorandum.
Same memorandum.
Same argument.
So same memorandum you have argued this point.
Same argument.
My lord, most of the cases where the directions have been issued earlier, my lord, those are pertaining to those 3 technical trades which have been carved out, exception have been created for them, my lord.
No, this is not factually correct. I have given the chart. My lord, operator radio line,
In one matter, my lord,
rifleman cipher,
Just a minute.
Havildar pharmacist, all these trade have been. These are the trade. He is saying this is not the trade. Havildar pharmacist, cipher, rifleman E, Havildar cipher, all have been given the benefit, implemented.
my lord,
Other than those 3.
what I would pray, my lord, otherwise if SLP is dismissed, I have nothing to argue, my lord. I have no case, my lord. That I admit, my lord. Only that SLP has been, the appeal has been admitted, my lord. Lordship kindly grants us
No,
time.
but if you give them the revision, subject to the result of the SLP, they are entitled to the revision, no?
Because what happens, my lord, even giving the pay revision also involves a lot of exercise, my lord, on our part.
So you initiate the exercise, and then before implementing it, by that time financial upgradation. This is a financial upgradation.
With effect from 1997, my lord.
So you have to calculate it. You carry out this subject to the result of the SLP, and we will keep this and you continue to process this, and but not to give effective for the time being, since the SLP is pending. Because you see, if your other cases you have already given the benefits,
Yes.
then in one case you prefer an SLP.
It's not one case. There were 18 matters were disposed of by common order, my lord. And we preferred appeal against the entire.
All the 18 orders.
All the 18 orders.
But apart from 18, there are other orders which you have implemented.
My lord, we've implemented mainly, my lord, maybe 1 or 2 here and there, my lord, deviations. But mainly with regard to 3 categories, my lord, which have been treated specially, my lord, by the government, by the pay commission itself. So we have implemented those. But it has happened, my lord, because of 1 or 2 matters where those were not covered within those exemptions, my lord, even they have been granted, my lord.
Even they have been given benefits.
They have been granted because of contempt proceedings and other things, my lord. And that was a long time back.
Lot of other cadres have been granted.
No, but if you are complying an order on the face of contempt, that is something different.
My lord.
But that is not an acceptance of the order. But if you are not preferred in appeal ultimately against that order, maybe because there is a threat of contempt, then you accept the order.
Yes.
You may comply with this, and to show that there is no contempt. But you can always say that subject to the result of the SLP. That is also available to you. So if you find that if you say that those matters, the issues there are the same issue here.
It's same issue, my lord. But if I may,
Lot of
if I
other
may
states
just
have been given the benefit.
because
and
because
went
what
to
happened, my
Supreme
lord,
Court also.
15 years back, 2010, 2008 and 9, some orders were passed, my lord, by the then Guwahati High Court. Maybe it was not. But if I take your lordship to the rules and office memorandum, even the earlier order of this division bench, my lord, if I may just read one paragraph of that order, my lord. The division bench said, my lord, this court cannot reopen the matter. You go up.
Even the Digambar Dutt case, they went to Supreme Court dismissed their SLP. Same is the case.
But the learned single
Because it is a cadre post, my
those
lord.
paragraphs, my
Havildar
lord.
and Rifleman is a cadre post of Assam Rifle. And once it is given to one set of Riflemen and Havildars, it should be given to all the
Is
Havildars.
this, if this issue is already covered by the decision of another division bench, then
Yes.
that is
But that's true, my lord.
that is also
As far
binding
as
on
there's no
us.
stay, there's no bar, my lord.
Binding
I admit
precedent.
that. I admit to that, my lord. But my lord, I was only praying, my lord. We are in the month of November. Time is given till maybe sometime February, my lord. We will try to expedite. If we are not able to expedite, or my lord may dispose of in February, my lord.
Take down. The learned DLCI, Dr. N. Musica, Dr. N. Musica, the learned DLCI, has submitted that a SLP is pending, that
to 12, Millets.
Yes.
Millets, I was making a prayer, Millets. Mr. Jointo Mitro, Millets, was leading us in this matter, Millets, with the arguments. Millets, some difficulty today he could not appear. If my lords kindly have it in the first week
No,
of
what
December.
is the issue here?
Millets, this is that matter concerning the Electricity Regulatory Commission, if my lords recall. There were two issues before the learned single judge, Millets, regarding retrospectivity and the power of recall. So that matter, Millets.
No, but there's an efficacious alternative remedy available.
Millets, there is a finding, Millets, by the learned single judge with regard to the power of recall in this matter.
a tentative finding only, my lord.
I'm only praying, Millets, if your lordships can.
No, where is the finding? Where is the finding?
Millets, I am
He is
sorry, Millets, I'm a
546,
little
my lord.
handicapped today because I'm not available physically. Millets,
546, my lord.
546.
Yes, my lord. Paragraph 38.
Five, four, six. Henceforth, I just have these orders. All the known appeal should contain. We may omit this line. Whether it's without jurisdiction or with jurisdiction.
Millets, I'm only praying, my lords, if my lords kindly have it, my lords,
Because
next week.
this finding, very well, we understand that if I say that this alternative efficacious remedy, then we don't pass an interim order or make observation.
True,
So
Millets.
we restrict ourselves to whether there is an alternative remedy available. So if you have an alternative remedy available, then you prefer an appeal.
My lords, I'm sorry, I'm a little handicapped today, my lords. The brief is not with me. My lords, may kindly have it next week. Otherwise, my lords, if first week is not is inconvenient with my lords.
Regulatory Commission has exercised jurisdictional review and passed an order, correct?
Well,
Or its order.
Lordship.
Recall its order.
Lordship.
Your lordship, the issue was, my lord, factual background is this, my lord, that the quorum, in fact, there were two members who heard, judicial member and chairman heard the matter, my lord. The chairman retired before the order could be passed, my lord.
Signed.
Single member passed the order, which was brought to the notice of the when quorum was complete. Then they heard the parties, and then the commission passed the order, my lord. That order was challenged by them before learned single judge, and even all these issues were raised. Learned single judge held that there is an alternative efficacious remedy in paragraph 39 at page 546, my lord, relegating the parties back to the appellate remedy, my lord. That's the issue, my lord.
No, there was no otherwise any power for recall under the Act.
My lord,
there is a power,
we
my lord,
say,
there is a
my
power
lord,
to
it is
recall.
our case. If my friend just permits me, my lords, it is our case that the Act and the rules, my lords, do not provide for any power of recall.
There is a power to recall, my lord, and the order passed by the single member was non-est because the matter was heard by two judges
If it
bench.
is
One
not,
No, you were saying that, what is the act? Let us have a look at the act. What was the act?
my lords, I'm extremely sorry. I'm a little handicapped, my lords. The brief is not available with me. My lords may kindly have it next week, my lords. I'll be in a better position to assist, my lords.
No, I just want to have a look at the act. Give us that. Give us that.
My lords may
that
kindly have the regulations, my lords. The regulations
is
are
quoted,
what-
my lord. If you lordship will see 525, learned single judge has quoted the relevant provisions of the act, my lord.
525.
Yes, my lord.
All orders of the commission shall be signed and dated by the chairperson and members hearing the matter and shall not be altered except to correct any apparent error.
Yes, my lord. And admittedly, this was the order which it was signed, but it was not signed by the chairperson.
This is not on the issue of recall.
Review is decision is there. Review is there.
Yes, my lord.
Review is there, my lords. Recall is not there. That was, my lords, the decision.
What about
that
the
we had
inherent? What are the inherent power of the commission? Nothing.
Yes,
in this
inherent
sorry.
power is also
My lords,
there. my
there,
lord.
the learned single judge has referred to a judgment of the Honorable Supreme Court, my lords, which deals with the NCLT, if I'm not mistaken. But then the language, my lords, of that particular bylaws and, my lords, the regulations of the MSARC are absolutely different.
No, aptel decision is also referred, my lord.
That was what was argued by us, my lords.
No, but you see, 26 is there. Nothing in this regulation shall be construed as barring the commission from exercising its power under the act for which provisions have not been made or have been made inadequately in order to subserve the spirit of the act.
Yes, 529.
True, my lords. But that would not give a sweeping power of recall, my lords. That was what has been argued.
Sorry?
That would not give a sweeping power of recall.
It's not a sweeping power of recall.
What had happened here
Once
is,
the inherent power is not defined, so inherent power when is not defined, it is something which, if the court finds that for the ex-deputy justice is required, they can do it. If there is a
well,
defect
here
or
the
something,
issue is a little
no
different,
one
because
can
this
take
power was
advantage
not-
of the fact that just because one person just on the verge of retirement did not sign it, even Code of Civil Procedure provide for it.
True, my lords. We did not come. The respondents came before you, my lords. We did not come. The respondents came before my lords by way of a writ petition initially. And my lords, thereafter there's been a spate of litigation, so I'll have to place the entire facts before my lord. Where, my lords, the commission then appears and says, "Oh, okay, very well, we will re-examine the matter."
No, you are the writ petitioner here. You are challenging the order.
No, my lords, in this round, I am the writ petitioner. Initially, when the order was passed by the single judge, by one single member, my lords, the distribution licensee, that's the respondents, came before the my lords by way of a writ petition. In that, my lords, they arrayed the regulatory commission as a party. Regulatory commission then came before this court, my lords, and said that we will re-examine the matter. It is not a suo motu proceeding by the commission, my
No,
lords.
they have what they have said. They have merely recalled it, and possibly they will adjudicate the issue afresh. That is possibly the
No,
order.
they have adjudicated it afresh, my lords. That's the second issue before my lords with retrospectivity.
No, that's not the merit of the matter.
I am extremely sorry, my lords. I am not in a position to assist your lordships with the relevant pages and documents. Or else, my lords,
But you are not disputing that there is a provision for appeal. Why, if the provision for appeal is there, accepting to the extent you are saying that the observation of the learned single judge, the acting chief justice, that this in the totality, therefore the impugned order dated such and such cannot be held to be illegal and without jurisdiction.
Well, it's because we had said, my lords, that the power of recall has to be, my lords, within specifically laid down.
What is this order of 23rd August 2024?
This is the order by which the order has been recalled.
So this order of 23rd August 2024, it can also be challenged by an appeal, isn't it?
No, it cannot be, my lords. That order cannot be challenged.
Yes, my lord.
That order cannot be challenged by
All orders are amenable to appeal, my lord.
show us the appellate provision.
529, my lord. (525) at 526, my lord.
Section 111, if I'm not mistaken.
Section 111, my lord. Any person agreed by an order.
Where is that page?
Page 526, my lord.
It's not adding. Two pagination.
Handwritten pagination, my lord. Handwritten.
Any person agreed by an order made by an adjudicating officer. No, but this is not an order made by an adjudicating officer.
Yeah, commission is an adjudicating authority.
This is not an adjudicatory order. That's
It's an adjudicatory order passed by the commission, my lord. Adjudicating officer is the commission, state commission, my lord, under the act.
No,
that is not in dispute, my lord.
No,
this is an order passed by an adjudicating officer.
Officer.
Well, it's recalling the earlier order by which there was an adjudication. So this itself is not an adjudicatory order.
No, but it says any order passed by an adjudicating officer, not saying only adjudicating.
I'm extremely sorry as I've submitted.
Or an order made by the appropriate commission under this act.
Yes, ma'am.
So this is not an order. This is the adjudicating officer.
This is an order made by the commission, my lord.
No, in this case, the adjudicating officer is
the commission, my lord. This is a state appropriate commission, is state commission.
No, who passed this order? Is the adjudicating officer?
This is by the regulatory commission.
So it's an order by the appropriate commission.
Yes, my lord.
Or an order made by an appropriate commission. It's not saying that it has to be any order made by an appropriate commission under this act may prefer an appeal to the appellate tribunal for electricity. This has to be so simple. Any order passed. Only thing is this, because of this observation, Mr. Advocate General.
Yes, I quite see what.
Yes, this illegal or without jurisdiction, this issue becomes conclusive.
What they invited
because the single judgment entered the petition on that count.
May I submit, my lord? The appellant invited the finding that on these grounds the jurisdiction of the writ court is made out. To limited extent, the learned single judge examined the issues and returned the finding. And then at the bottom, if your lordship will see, that has been clarified. If your lordship will see paragraph 38.
But you see, Mr. Advocate General.
Yes, my lord.
If I challenge an order and saying that it's without jurisdiction, then if I say that now it's with jurisdiction and then you have an alternative efficacious remedy, then that remedy is one hand you are giving it, the other hand you are taking it away.
I bow down to the extent, my lord, what your lordship in my humble submission can modify that without being influenced by the observation made, the appellate tribunal can decide the matter, my lord. To that extent, that will take care of their grievance.
We are saying that it is not even within the four corners of the statute. We have to satisfy your lordship's melons, the learned single judge, the findings on the basis of which the findings have been rendered by the learned single judge melons. We are saying that it is incorrect.
An order passed in exercise of his jurisdiction, whether it is correct or wrong, it's appellable.
That is an appealable order.
So writ court will not touch.
My lords.
But we are saying, this is not a matter. This is not a matter which could not have been decided. It is in the domain of the adjudicating authority or the appropriate authority.
My lords, we are saying it is not.
No.
We are saying that order of 23rd August is not.
Or see, there are two kinds of things. One is I pass an order. This order I pass in jurisdiction.
Lordship.
It's an order without jurisdiction. Then what I did is this: I recall this order. Question
Right.
arises whether you have power to recall or not.
Absolutely, yes.
So
This is
there are
error
this.
within jurisdiction, my lord. This is
So there
error
is.
within jurisdiction.
So this is not one of the cases where the writ code will apply or call for a
Malaj,
session.
the learned single judge Malaj has rendered a finding on the basis of Malaj after going through the regulations, saying that the power of recall is available. We are
Yes,
saying
because of that inherent power. If the inherent power commission finds that if the inherent power the commission finds that there is suppose the order passed passed by the appellate authority or whatever is there, suppose it's a quorum non judice. So I cure the defect. If it is a quorum non judice, I cure the defect by constituting a proper tribunal and decide the matter. That's why it is recalled.
Malaj, here the
If
issue
the
is
chairman suppose 3 persons are sitting, one person there is an order passed, but one person did not sign because he retired from office.
Lordship.
What has happened in this case?
Malaj, here, Malaj, what we pointed out before the learned single judge is, Malaj, there is an order passed by a full bench of the APTEL which actually permits one member to sign it. I'm sorry, Malaj, I don't have the papers with me.
One member's, you should have the papers because if this matter was adjourned, it's no excuse that you don't have the matters. Don't show your, don't make excuses on this because you are aware of it. And you also aware that you are to address us today on the alternative remedy. So you are fully aware of this. If the papers are not with you, you have to blame yourself, not blame us.
Absolutely, Malaj.
The question is this, the question is this, that if this one member or 2 member, whatever is there, if they have passed an order, and suppose one of them have not signed it,
Malaj.
then what would happen?
Malaj, which is what I was humbly submitting before.
Under the Code of Civil Procedure, if judgment is pronounced and for some reason the successor to the office can sign the judgment.
Has to sign it. Malaj.
If it is pronounced, for some reason is transferred, cannot.
Malaj.
Tribunal, they have dealt with the issue. One of them has not signed the order.
Malaj, what had happened is, in this, what we had pointed out before the commission was, Malaj, that there is a full bench judgment of the Honorable APTEL, which categorically says this, Malaj, that any one person can sign the order.
Correct.
That we had pointed out, Malaj.
So anyone has signed the order.
In
your case, one person has signed the order.
One person has signed the order.
And then what happened?
The matter was heard by 2. Not
So
by
that's
1.
not on dispute. That's not on dispute.
And matter was heard by 2, and therefore the order was recalled, and the fresh tariff order was also passed, my lord. So recall order was challenged separately, and tariff order has also.
Order was passed separately.
Tariff order was also challenged, my lord.
Separately.
And therefore the
Separately.
learned single judge, it's why after framing the issues, my lord, at page 523, it held that the tribunal has power to recall its order. One.
In your case, factually, 2-member panel, correct?
Correct.
2-member panel. So, did they pronounce the judgment in openly or?
No, my lords. No. It is signed. It is not like a court proceeding, my lords. After the hearings happened, there's a public hearing, my lords. That was taken up by
public hearing. So it was not pronounced, but one member signed it.
Yes, my lords.
No, it was pronounced, my lord. It is properly pronounced, my lord.
No, it is not pronounced in open court.
June, I have that in date, my lord. But be as it may,
and
my
it
lord,
is not the first case, my lords, where one member has signed it. We have pointed out.
So one member signed it. What about the other member? Other member retired by that time.
My lords, the chairman by then had demitted office.
So therefore, single member.
So on the date when the judgment was pronounced, there is only one member.
There was only one member.
Then how it could be judgment?
My lords,
if on the date of the judgment, one of them by that time retired,
my lords,
then how he can form the quorum for the judgment? It cannot.
My lords, it is provided under the Act as well as, my lords, the judgment of the APTEL, my lords, it is provided.
It is provided that notwithstanding that remedying the office by the person concerned,
my lords, that would not vitiate any orders.
How it is possible? How it is possible in law?
I will have to just point it out, my lords. I will have to show it. My lords, that may not find favor with my lords. but I'll have to
Sorry.
point it out.
Cannot be accepted. Impossible.
My lords, it is a, my lords, if I may, it is a statutory function of the commission, my lords.
Civil procedure.
My lords, CPC. If my lords have the Electricity Act, my lords, things would become a little more clear.
Well, that is your point. Very well.
527, my lord, your lordship, we kindly see 527 quorum is defined, my lord, in the regulation framed under the Electricity Act, 527, my lord, of the paper book, my lord.
General, we have heard the Land Advocate General.
Issue that for determination that was raised before the learned single judge, my lord, was whether the selection process, my lord, made by the Meghalaya Public Service Commission to the post of the state organizer, Bharat Scouts and Guides, my lord, is vitiated by fraud, misrepresentation, favoritism, my lord. And if so, my lord, whether the judicial review and interference is warranted or not, my lord. Now, what his lordship has done is, my lord, His Lordship has dismissed my writ petition, my Lord, holding that I have no locus standi to challenge the recruitment process, my Lord. My Lord, such a serious allegations I was making, my Lord, here. So, my Lord, just brief facts of this case is that my Lord may come to page 54. Page 54. This is my Lord has got page 54.
Yes.
My Lord, this is an advertisement, my Lord, issued by the Meghalaya Public Service Commission for filling up of various posts in the various departments, my Lord. And what we are concerned is at page 57, my Lord, serial number 13. Page 57, my Lord, serial number 13. That is what we are concerned with. That is for, my Lord, state organizers, scouts and guides. And then kindly note the experience, my Lord. The experience served as an assistant organizer for more than 3 years in the state or in other state Bharat Scouts and Guides. And the number 2 is, my Lord, must have completed graduation in scouting, guiding of any section, HWB holder. Number 3, my Lord, must have attended national events, conducted leadership training in the state and district, my Lord. Now, pursuant to this advertisement, my Lord, 29 candidates applied for the post, my Lord, for the post of state organizer, my Lord. And, my Lord, by page 62, page 52, my Lord, page 62, my Lord, all the candidates, my Lord, all of them, 29 candidates, including myself, my Lord, the appellant, got rejected, my Lord. The candidature was proposed to be rejected, my Lord. And the reason for me to propose to be rejected, my Lord, my name is a serial number 2 of page 62. The reason given was, my Lord, does not have experience as required by the advertisement. And now, my Lord, the private respondents' names are at page 63. Page 63, my Lord, from the second from the bottom. The second from the bottom, that is the respondent number 4. Now, the reason for her also does not have experience as required by the advertisement. And my Lord will see the 5th one from the bottom of page 63. That is the respondent number 5. And the reason also does not have experience as required by the advertisement. So, all of us, 29 of us, got rejected, saying that we don't have an experience as required by the advertisement. Now, this proposed itself opens up an opportunity for any person who is aggrieved by this proposed rejected list to file a representations. Now, 6 of us, my Lord, 6 candidates, including myself, we file our representations, my Lord. And out of the 6, my Lord, two candidates were found to be eligible. That is the respondent number 4 and 5, my Lord. Now, till here, it is fine, my Lord. Now, seeing the name of the respondent number 2 and respondent number 4 and 5, my Lord, in the select list, there's some doubt has arose, my Lord, in my mind. Because I am working in Bharat Scouts and Guides as an assistant organizer, permanent member, my Lord. So I know very well, my Lord, these people have not worked in Bharat Scouts and Guides as required as per the advertisement. So I have filed my RTI applications, my Lord. Page 65 is my RTI applications, my Lord. Page 65. And my Lord, I will just read the RTI applications carefully, my Lord, because this has got a bearing, very much bearing, my Lord, in this case. Number 1 question that I've asked is, whether the eligible candidate accepted at serial number 1 and 2 by notification mentioned above are really the candidates being appointed or recognized as assistant state organizers or state organizers, Bharat Scouts and Guides by the Meghalaya Bharat Scouts and Guides state headquarters. If yes, please provide proof, documents and appointment orders. Number 2, my Lord, if the question at serial number 1 is yes, please mention whether the eligible candidates accepted as serial number 1 and 2 via notification mentioned above are really being appointed or approved by the committee or by the competent authority as assistant state organizer or state organizer scouts and guides. Number 3, my lord, if the candidates are being appointed or approved by the committee, please provide proof, documents and minutes of the committee. Number 4, my lord, if the candidates are being appointed or approved by the competent authority, please mention under whose competent authority. Number 5 question, my lord, whether the eligible candidates accepted as serial number 1 and 2 by notification mentioned above are really a scout master or guide captain for any unit as per the record of the office. If yes, please mention the name of the unit and provide proof, documents and warrant appointment order. Number 6 questions, my lord, whether the eligible candidates accepted as serial number 1 and 2 by notification mentioned above have really attended national events, conducted leadership trainings in the state and district as per the record of the office. If yes, please provide proof of more. I never got answer to this at all, my lord. But there was an order, my lord, by page 63. I was allowed to inspect the documents, my lord, submitted by the respondents, my lord. I was allowed to inspect. By the order dated, my lord, 20th of December 2021, that is at page 67. By this order, I was allowed to inspect, my lord. And I found this experience certificate, one of the experience certificate, my lord, which is at page 69, my lord. And this experience certificate, my lord, says that para 2, my lord, it says that although not fully employed, Ms. So-and-so has been serving as honorarily non-salaried assistant state organizer and a member of the state executive and state council of the Meghalaya Bharat Karnaga since 2016. Now, my lord, besides all, 2016 she was never. So therefore, what I did is I filed one RTI to the office, my lord. And my RTI, my lord, will see at page 100 again, my lord. My lord has got page 100. So I sought informations, my lord, of the list of employees who were working as honorary for the year 2015 and 16, and the list was provided to me in page 101. Now, my lord, page 101, my lord, will see there are 24 employees who were honorary members, my lord. The respondent numbers name were not here, my lord. And also, my lord, I have asked for who are the employees of the Bharat Scouts and Guides for the year 2015 and 16. And the list was provided to me by page 102. 102, my lord. And even here, the respondents' names were not there, my lord. So therefore, in no way this experience certificate could have been issued saying that she was an honorary member since 2016, my lord. So this is one point, my lord. So when, my lord, now, my lord, the appointment orders of the assistant organizers was also not there. Experience certificate, in spite of saying that these particular names are not a member of in the year 2016, yet the experience certificate gets issued. Why it was issued, my lord, that puts a question, my lord. In order to make somebody eligible who was ineligible in the first instance, my lord. Now, my lord, they have got appointment thereafter, my lord, in spite of the best effort, my lord. Now, my lord, I will just show to the 103. This will further prove what I am saying, my lord. Page 103, my lord, is a revised service and conduct rules of the Meghalaya Bharat Scouts and Guides, my lord. And my lord will see at page 112. My lords will see at page 112, that is the F, my lord. Assistant State Organizer, Commissioner, Scouts and Guides. It says that the person appointed to this post must be a graduate from any stream with knowledge of computer at the MS Office level and work as computer operator. Number 2, my lord, to be trained as a scoutmaster, guide captain who has completed the advanced course.
Mr. Counsel, to cut the matter short,
My lord.
the certificate produced by them, as opposed to your certificate,
Yes,
they are signed, it is not signed.
my lord.
And the certificate genuineness, you have raised questions, forensic examination is in favor of the certificates. Till now, no court of law has declared the certificate to be bad. Matter ends.
I follow my lord.
Matter
That
ends.
that is not only my point, my lord. My point is, my lord, when somebody, my lord, when somebody is not eligible, my lord.
He's eligible because that certificate was required. She produced the eligibility. All of them were given opportunity. You did not produce. The certificate you produced was unsigned, as opposed to their certificate which is signed. You got hold of that person who signed this to declare that is a false signature. Went to the forensic examination. Forensic reports found the certificate to be genuine. And then and still now the certificate is to be genuine, then that holds the ground more than that favors you.
My lord, then the question comes. Then the question comes of favoritism, my lord. Then the question comes favoritism. If that be the
You
case,
are not even eligible. Favoritism will come later. First you establish your right.
my lord, what
You are
happens?
ineligible.
No, my lord, what happens, my lord? My lord, what happens, my lord? If I'm able to, my lord, how I'm not interested, my lord. If these candidates, my lord, who has been by force, my lord, give to the appointment, my lord, if this entire selection gets squashed, if this selection gets squashed, my lord, I become eligible because I'm HWB. The question is that, my lord, my eligibility, the question is that only my experience is not signed, my lord. Kindly look at my appointment order.
We are not. When this advertisement was open,
Yes.
everyone was given opportunity. They produce a certificate duly signed. Your certificate was not signed. So obviously that carries more weight than yours. And you try your best, and the person who signed it, she made a complaint, went up to investigation, FIR, everything was there, and then forensic examination report was filed saying that signature is genuine.
My lord, can you
We
appreciate?
are not entering into this. We are not.
My lord,
entering
can you appreciate this, my lord? My lord, the person who signed this certificate herself, she says that she's not the one who signed this certificate. And maybe, my lord,
There was a forensic examination.
of course, there was a
File a
forensic.
suit, declared that the certificate is invalid in law. In a writ petition, will that be gone into your case?
Because my point here,
Have it set aside, declared to be forged, and then forfeit his service.
my lord, the writ why I have come before court is, my lord, and my lord knows very well, my lord, any person who by misrepresentation or by playing.
How can we say it's a misrepresentation?
My lord, when the list, my lord, 2000, the list of the employees for the 2016-2015, my lord, their names is not there. Then how can somebody give a certificate saying that yes, he was a member? Well, as good as today, I am not a law student, my lord, and I get a certificate by the principal that I'm a law student. And tomorrow I get secure some job because of one certificate, my lord, in the absence of any other supporting
You
certificate.
also give a certificate, then you are also to be faulted. If you say they have not, then on what basis you are claiming? Then also you fall in the same line.
My lord, my appointment order, kindly see, my lord, the SO's appointment order, my lord. Page 85, my lord, just have a look what page 85. My
Your
lord.
certificate is unsigned.
My lord, but my lord, page 85.
An unsigned certificate, will it have a evidentiary value? Please tell me.
My lord,
Suppose your bar council certificate is not bearing signature.
yes.
You 5-year law and there is no signature of the vice chancellor of the comptroller examination. Will it be a valid?
No, it will not be valid, my lord. But it
So
will,
here he has a certificate. All 29 candidates were rejected. Then there's a fresh, they were given chance to cure. they cure the defect by producing a certificate which bears the signature of the person concerned, as opposed to yours, where you have filed the certificate in 2023, not even in 2021.
My lord,
So in 2023 you give a certificate
Yes.
which does not bear the signature of any person.
very well, my lord. Can you look at page 80? Just last page, my lord. I'll just show, my lord. Just one page, my lord, which I'll just show, my lord. This is this is the letter issued to the respondent number 4 after getting selected, my lord, by the MPSC, saying that let
Respondent
us,
number 4 is saying that I have not signed it. Correct?
no, respondent number 4 is not, is a candidate, my lord. Who is the
Yes,
beneficiary?
respondent number 4 is a court job. Yes,
Yes,
correct.
who is the beneficiary? Now MPSC asks them, let's verify. I'm going to give you a job, let's verify the documents. And what kind of documents have been verified? The documents that are supposed to be verified are not verified. This itself shows, my lord, there is a favoritism. Can you look at this page 80?
Favoritism will come later. First you establish. If you say favoritism, you have to be eligible first. That he is being favored over you.
My lord,
Correct?
yeah,
When the favoritism will come.
yes.
Between the three, one is favored, although I have the same qualification.
Yes.
I stand on the same footing.
Yes.
Your document is lacking.
My lord, my appointment order 2016, my lord, at page 85. This will testify, my lord, why I'm not eligible, my lord. One experience certificate, unsigned experience certificate does not matter, my lord. This is a testimony. I have been serving more than I've been eligible, my lord. Can you look at this, my lord, page 85? This is a appointment order, my lord, page 85.
Anything else? Anything else?
My lord, actually, I have lots of things to say.
Thank you. Reserve for judgment.
My lord. Few judgments are there, my lord, which I am placing, my lord.
Don't
So,
require any judgment. Reserve for judgment. Yes, for the list.